Second internal, important questions and answers. Label or 2. What is the law that regulates employment of women in certain periods? Answer is Maternity Benefit Act 1961 regulates women employment before, during and after childbirth. Second question, to which sector EPF Act does not apply? EPF Act does not apply to 1. Cooperative societies with less than 50 workmen, central government and state government undertakings which have a contributory provident fund, establishments set up by central and state government with contributory provident fund and pension, and other establishments which government specifically exempts. Third question, adult definition under Factories Act. Adult is 18 years of age under Factories Act, adolescent is 15 years of age, and child is 14 years or less. Who are the functionaries under Section 3 of the Payment of Gratuity Act? He is the Chief Labour Commissioner and the employer. Next, which act aims to prohibit children's employment in certain occupations? Answer, Child Labour Prohibition and Regulation Act 1986, below 14 child in 18 occupations and 65 processes. Number of days used in calculation of gratuity, it is 15 days per year. The salary is basic plus DA, maximum is 10 lakhs and now increased to 20 lakhs. Seasonal, less than 7 days per season. Next question, where is the welfare officer appointed under Factories Act? When you have 500 workmen, welfare officer is appointed. Definition of wages under Maternity Benefit Act. Average daily wage for absence, 26 weeks, 8 weeks before delivery, 3 months average, 3 monthly average is taken. 10 workmen plus 80 days working last 12 months, they are eligible. 10 workmen in an establishment, they are eligible. Next, which fund is created by contribution of employer only? Workmen or employee compensation fund is created by employer's contribution only. Next, definition of factory. Any premises or precincts with 10 or more workers working on any day in the preceding 12 months and any part of the same premises a manufacturing process is being carried out with power, or even without power it is 20 workers. It is a factory. Main issue is manufacturing process. Even a single process which changes the nature of the product is sufficient. Next question, what is EDLI? It is Employees Deposit Linked Insurance Scheme. 12. Which sector of Factories Act deals with health and safety provisions? Chapter 3 of Factories Act deals with health and safety provisions. Sections are 11 to 20. Section 11 deals with cleanliness. Section 12 with disposal of effluents. Section 13 with ventilation. 14 with dust and fumes. 15 with artificial humidity. 16 with overcrowding. 17 with lighting. 18 with drinking water. 19 with latrine and urinals. And 20 deals with spittoons. Now the formula once more, it is last pay by 26 into 15, it is not 30 days. Last monthly pay drawn divided by 26 days into 15 days into number of years. Gratuity. Formula for, therefore, month calculation is 20 days. Formula for calculation of gratuity for piece rate workers. It is the same thing. Piece rate is daily calculated and then average is taken, 3 monthly average. Monthly pay is taken divided by 26 into 15. Number of workmen required for a creche. Under Factories Act, 50 women workmen are required for having a creche. Number of weeks eligible for maternity leave, it is 26 weeks. Who administers ESI funds? It is ESI Corporation. What is the gratuity? Gratuity is for a long period of work rendered by the workman, a payment to help in his post-job life and to have for all the hard work he has rendered to the company. It's a kind of a present for having been loyal to the company. Welfare provision under Factories Act. First, occupation and health care. Second, suitable working time and working conditions. Third, appropriate salary. Fourth, physical, mental, moral, emotional well-being of an individual. Safe working environment, no health hazard. The health hazards may arise from lack of cleanliness, disposal of waste, ventilation and temperature, dust and fumes, artificial humidity, overcrowding, lighting, drinking water. When there are more than 250, cool drinking water should be given. Latrine and urinals, spittoons. Safety, fencing of the machinery, work near machines in motion, employment of young on dangerous machines, and striking gear to cut off power. Welfare others are self-acting machinery, casing of new machinery, prohibition of employment of women and children near cotton openers, hoists and lifts, and lifting machinery, chains, ropes, lifting tackles, revolving machinery, pressure plant and safety, floor, stores and means of access, pit, sump and opening in floors, excessive weight, protecting eyes, precaution against dangerous fumes and use of portable light, explosive, inflammable dust and gas, precautions in case of fire, safety of the building and machinery. Then welfare measures, washing facilities, accessible and clean, facilities for storing and drying of clothes, facilities for sitting, rest between works, first aid box. When 150 workers are there, one first aid box is necessary with a trained person. When 500 workers are there, ambulance room is necessary with medical and nursing staff. Then canteen, 250 workers, the canteen is required. Government rule on quality and price. Case is Elangovan versus Madras Refinery. Next, shelter, a restroom or a lunchroom. For 150 workers, lunchroom or a restroom with drinking water is required. For a creche, 50 women workers with a trained woman in charge, a creche should be run. Welfare officer, 500 women welfare officer should be appointed. Employees Association of Northern India versus Secretary of Labour, 500 workmen are required for a factory, even a sugar factory. Welfare facilities outside the factory, their maternity benefits, gratuity, pension, PF, medical benefit, ESI, educational facilities, housing facilities, recreational facilities, literary and reading room, holiday home and leave travel concession, consumer cooperative stores and fair price shops, vocational training, and transport to and fro the place of work. Next, Factory Act changes. What are the changes it has made recently? 1. 10 persons with power, 20 persons without power. That is our definition of a factory. There is no distinction now between seasonal and non-seasonal factories. Minimum age hike is 12 to 14. Minimum age earlier was 12, now 14. Reduces hours of work from 5 to 4.5 for children, that is 14-year-old. Prohibit children from working after 7 p.m. and before 6 a.m. Explicit focus on health, safety and welfare of the workmen. Next question, benefits under EPF Act, monthly benefit for superannuation, retirement benefit, disability benefit, survivorship benefit, widow or widower benefit, children or dependent children benefit, saving for long term, the monthly deduction, emergency help, savings at a time of retirement and no withdrawal before 5 years. If you withdraw for 5 years, you have to pay interest. You have to take a loan and then you pay interest on that and repay it. Next, formula for calculation of gratuity. Gratuity, average salary, that is basic plus DA, divided by 2 into number of years of service. Service years are not rounded off to next number, that is 12 years, 10 months is not 13 years but 12 years only. 15 years into last pay drawn into working tenure by 30, somewhere it is given as 26 number of people, number of days in a month. Basic 30,000, 7 years service, that is 15 into 30,000 into 7 by 30. It is 26 days actually. Constitution of India Provisions for Child and Adolescent Labour Prohibition and Regulation Act. Article 24. Constitution of India prohibits employment of children below age of 14 in factories, mines, other hazardous employments. Article 21A and 45 promises to provide free and compulsory education to all from 6 to 14 years age. Up to 6, the parent is responsible for giving education to the child. Child and Adolescent Labour Prohibition and Regulation Act 1986, Notification 1993, prohibit engagement of children in all occupations and to prohibit engagement of adolescents in hazardous occupations and processes and the matters connected therewith, incidental thereto. Next, freedom of labour over. Now, public interest law, 3rd, 4th and 5th units. Freedom of high seas. High seas shall be reserved for peaceful use by all. No state may validly purport to subject any part of the high seas to its sovereignty. Every state, including landlocked states, have a right to sail ships flying its flag on the high seas. UN Convention on Law of the Sea, number 7. Next is Nottebohm case. It is a Liechtenstein versus Guatemala case. Nottebohm is actually German national who, to escape Second World War problems, obtained Liechtenstein citizenship by payment of money. When he was in Guatemala, Guatemala reported him as a German national. It's a 1955 case. Court held the Liechtenstein claim that Nottebohm was its national was inadmissible. The bond of nationality should be between a state and the individual, and decides he is the German national, and Guatemala is correct in reporting on him to the International Criminal Court. Now next, International Criminal Court, ICC, including relevant cases. ICC investigates, tries individuals charged with the gravest crimes of concern to international community like genocide, war crimes, crimes against humanity, crime of aggression, court of last resort. It complements national courts governed by Rome Statute, world's first permanent ICC. The Assembly of States state parties is courts management oversight and legislative body. States ratified plus acceded to Rome Statute. Next question, legal regime of airspace, treaties and conventions, basic principles plus international air law plus every state has complete and exclusive sovereignty over the airspace above its territory, including above its territorial sea. It's affirmed in 1919, Paris Convention on Regulation of Aerial Navigation, 1944, Chicago Convention on International Civil Aviation, 1958, Geneva Convention on High Seas, which also includes air above it. Next 5, exclusive economic zone. 3rd UN Conference Law of Sea, 1982, coastal state assumes jurisdiction over the exploration and exploitation of marine resources in the sea adjacent section of the continental shelf up to 200 nautical miles from the baseline. Next question, jus cogens, compelling law, fundamental plus overriding principles of international law, a peremptory norm of general international law that's accepted by all states and no derogation is permitted. Next question, Unispace Conference, UNOOSA, UNUSA. 3 global UN conferences on outer space, global space governance, peaceful uses of outer space. 2030 agenda is solutions for the space safety and sustainability, together for change and protection of the space. UNESCO, UN Economic and Social and Cultural Organization. It is a specialized UN agency for world peace and security through international cooperation in education, art, science and culture. Double nationality. A national is a person who has citizenship in 2 or more countries at the same time, by birth or by naturalization. Same rights of obligations as a single national will have. That is double nationality. Next, methods of termination of a treaty. 1. Fraud, error, corruption of the state representatives. 2. By consent of both the parties. 3. Expiry of the specified period of the treaty. 4. Main object is fulfilled of the treaty. Then one of the parties' state is extinct. Then when obligation is incompatible with the UN Charter and war between party states, then dissolution by withdrawal of notice, terms injurious to state, then non-performance of certain essential conditions by one of the states, then doctrine of rebus and stantibus, unforeseen changes imperiling the state, then just cogence violates the peremptory norm of general international law. These are the ways in which a treaty can be terminated. Next subject is iOS 4 and 5. First question, internal aids of iOS, they are preamble, proviso and schedule. Preamble, it contains the main objects and reasons for the act. When more than one meaning is coming out, and help of the preamble can be taken. Case is West Bengal versus Anwar Ali regarding special courts to deal expeditiously with drug offences. Next, proviso. Proviso is a qualify or an exempt mandatory condition, optional addendum, is an integral part of the act and can neither nullify nor can enlarge the scope of the section. Schedule. Schedule is part of the law. It is given at the end. Details to working out of the details or mechanisms or list of items. Policies, lists, and main body is given more importance than the schedule if there is a fight between the two. Proviso has wider than exemption. Magnitude. Bengal Immunity Company versus Bihar, heading Trolley versus Gidding. Next question is external aids of iOS. Their legislative history, dictionary and foreign decision. Dictionary. Act does not define a word, it is unclear, then refer legal dictionary used in the same context. Case is Motipur Zamindari versus Bihar, defining of sugarcane whether it is a vegetable. Held not a vegetable. Foreign law and decision. If jurisdiction is similar and political system is similar and no domestic law is present, foreign court decision is not taken to be arbitrary, then foreign law decision can be used. Legislative debates. In bill passing session not fully reliable as colored by political views of the MP, Madhya Pradesh. Repeal under under General Clauses Act. Commencement of an act or effect of amendment, section 6A, effect of repeal, shall not revive anything not in force. A. B. Shall not affect the previous operation of any law so repealed. C. Shall not affect any right, liability acquired, accrued or incurred under any law repealed. D. Shall not affect any penalty, forfeiture or punishment incurred in respect of any offence committed under law so repealed. E. Shall not affect any investigation, legal proceeding or remedy in respect of such a repeal, privilege or right, privilege, liability or penalty, forfeiture or punishment. And any such investigation, legal proceeding and remedy may be instituted, continued or enforced. Such penalty may be imposed as if such repealing act has never been passed at all. Next, excessive delegation or when parent legislation should not be delegated. If legislature excessively delegates its legislative function to other, it is unconstitutional. Legislature must declare the policy of the law, lay down the legal principles and provide standards. Exposition. Grounds of application, scheme of law of acts and circumstances as a background. Next question, elaborate function, which is subordinate legislation, should not contain in its scope power to repeal or modify a law, retrospective operation, judicial functions of per rules of the court. What is delegated could not be further delegated by delegatee, means power to tax. These are the things that cannot be delegated further. Next question, presumptions. Presumption is that court has the jurisdiction unless otherwise is proved beyond doubt. Rebuttable presumption is a judge to reach a certain conclusion before hearing any evidence unless the evidence later presented before him convinces the judge to reach a different conclusion. Next question, effect of repeal on vested rights. Effect of repeal is to obliterate the statute repealed incompletely as if it had never been passed. Vested right is not affected if it is concluded. Repeal shall not affect any right, privilege, obligation or liability acquired, accrued or incurred under repealed act. It shall not affect any penalty, forfeiture or punishment incurred in respect of any offence committed against the act. Not taken away right to appeal is vested right by repealing statute. Next subject, land laws. Scheduled areas and prohibition of transfer. Under Schedule 5 Article 244, Clause 1 by President, whole or part area of a state is declared or increased or adjusted the boundaries to consult after consultation of the governor. Alter. Preponderance of tribal should be there, compact and reasonable area should be there, underdeveloped nature of the area should be there, disparity in economic standards should be there with other areas in the state, and tribal advisory council is set up. Sale is allowed only to another ST or a ST cooperative. Next, concept of rehabilitation and resettlement with reference to Land Acquisition Act. R&R and socio-economic survey and social impact assessment basis. Compensation for a land, house, shop, home, homestead, land, transportation, change for household items, cattle and construction of hens, house, solatium charges, cost of cattle shed, poultry fees in construction, agricultural land alternate being provided, subsidy for seeds and fertilizers, develop PHC, school, community center, basic roads, water, electricity, medical facilities, vocational and entrepreneurial training, special for ST, and renovate temples and religious places. Next question. Assign land and prohibition of transfer. Land assigned by government to landless poor subject to condition of non-alienation under rules prevailing. For agricultural purpose only, no power to sell or transfer the land. He can only mortgage it for obtaining a bank loan, either from cooperative society or a nationalized bank. Meaning of public lands. Public land is not just a human. They are protected ecosystems for survival of wildlife also. Public lands are owned by all citizens and managed by the government agencies on behalf of the society. Next, public purpose under Land Acquisition Act and also for companies. Section 40, Clause 1, grounds are given. 2 Clause 1, project which involves land acquisition for strategic purpose, national security, defense, infrastructure, project for common welfare, and public health and safety or welfare, but not limited to it. Even for a company also, it is going to serve public, then it is a public purpose. Next question, constitutional provisions pertaining to scheduled areas, Article 244, Clause 1 and 5th Schedule are the constitutional provisions. Administration and control of scheduled area and scheduled tribes in any state other than the state of Assam, Meghalaya, Tripura and Mizoram, that is 7 sisters. To preserve tribal autonomy, their culture, economic empowerment, to ensure social, economic and political justice and preservation of the peace and good governance. Next question, ceiling limits and standard holdings. Family unit is not more than 5 members, 1 standard holding, 1 by 5 extra for each additional member, adult member. Total number not more than 2 standard holdings. How many may be the numbers? Under Section 4. Wetland is 10 acres, dry land is 25 acres, notified date is 1175. All transactions 24/1/1971 are to subject to scrutiny. Unnamed, unmarried minor daughter is part of the family unit. Co-widow is a separate family unit. Double crop wetland and other wetland. The comparison is Class A. Double crop wetland is 10 acres, other than wetland 15 acres. Class B 12 acres and 18 acres. Class C 13.5 acres and 20 acres. Class D 15 acres and 22.5 acres. Class E 16.5 acres and 25 acres. Class F 18 acres and 27 acres. In the case of dry land, it is G class 36 acres, H 40 acres, I 45 acres, and J 50 acres and K 54 acres. IPL, intellectual property rights. Define design. A plan or a drawing produced to show the look and function and workings of a building, garment or other object before it is made. A decorative pattern or look and functioning of the building, garment or an object is called a design. Next, complete specification. Complete specification, title of the invention plus description of the invention plus at least 1 claim and any drawings required to illustrate the invention and its working. It must be novel. Most complete attempt at a description or defining the invention plus self-contained document plus description clear enough and complete enough. Next question, define geographical indicators. GI, name or a sign used on product which correspond to a specific geolocation, area or origin or a district which contains an IP right to identify a product that originates from that particular area, specific geographical area, has a quality, reputation and characteristics attributable to the geological origin. geographic origin. Next, difference between infringement action and passing off remedy. Passing off is standard tort law remedy. Trademark infringement is statutory therapy. Trademark infringement, criminal law prosecution. Passing off is action of deceit. Trademark infringement claims exclusive right to use the mark on these goods. 5. Grounds for revocation of patents: wrongfully obtained the invention, anticipation by prior publication, anticipation by prior claim in India, invention is in public use, knowledge before the priority date, invention is obvious without inventive step. Next, absolute grounds for refusal of registration of a trademark. Section 9, Clause 3, trademark consists solely of shape of goods which result from the nature of goods themselves, shape of goods necessary to obtain a technical result, shape which gives substantial value to goods, therefore needed to, but it is not distinguishing from others. Case laws is Philips Electronics versus Remington Consumer Products, 1999. 3 triangular rotating blades are needed for a technical result, else no trademark can be given. Next, Schedule 5, Panchashil Doctrine by Nehru. People should develop along the line of their own genius. We should avoid imposing anything on them, encourage their own traditional arts and culture. Tribal rights to land and forest should be respected. Try to train and build up a team of their own people to do the work of administration and development. Should not over-administer them. Those areas are overwhelm them with multiplicity of schemes. Work through their own social and cultural institutions. Should judge the results not by the statistics or amount of money spent, but by the quality of the human character that is evolved. These are all the important questions and answers.